Okay, so there are some few interesting obligations on the mediator. Tell me a bit more about giving reasons for withdrawing.
Yeah, so that's a kind of an interesting one as well, because obviously, you'll know the same from working as a mediator. There could be a myriad of reasons why a mediator might feel they need to withdraw from a mediation process. There could be a conflict of interest that has appeared. They might feel that they're not the right mediator for the matter. There might be issues related to the parties. There might be bad faith on the part of the parties. And if it's a case such as, for example, the mediator feels that the parties are not participating in good faith and are really only coming to mediation in order to tick a box, that I would have certain reservations about reporting on that reason for my withdrawal in writing. So mediators just need to be a little bit aware of what their reasons for withdrawing are and what the implications might be of giving these reasons in writing, because one can't, of course, rule out that report, those reasons being introduced in legal proceedings in the future, being used tactically. You just don't know where that report or where those reasons might end up. So I would urge mediators to think about how they frame any reasons for their withdrawal so that they don't inadvertently end up putting one or both of the parties in a position where they might face some sort of sanction or penalty for withdrawing from the mediation.
Okay, so the mediator would put their reasons in writing to the parties and then
Yes.
back to the
Yeah.
court?
Well, we'll come back to the court reporting duties later on, but initially to the parties anyway. But then the parties may well, of course, bring them to their solicitors or bring them into any process that might happen after that.
Okay. And what about managing conflicts of interest? How does that?
Yeah. So that's quite an onerous obligation as well. So there are two different provisions in relation to conflicts of interest. One is it relates to the stage before the mediation has actually commenced, where the mediator has to ensure and make such inquiries as are reasonable to ensure that there isn't a conflict of interest, and if so, to disclose it to the parties. And likewise, if it becomes apparent to the mediator or ought, taking all the circumstances into account, have become apparent to the mediator in the course of the mediation that there's a conflict of interest, they must disclose this to the parties and must withdraw unless the parties specifically decide that the mediator can remain having disclosed this conflict of interest. And sorry, go on.
Okay, so if there is a conflict of interest, unless the parties are fine with the mediator continuing, despite there being a conflict of interest, they are obliged to withdraw.
The mediator will be obliged to withdraw. Yeah. And, I suppose it's not to be taken lightly. First of all, in a small country like Ireland, it would not be unusual to suddenly find that somebody involved, or some of the facts that are disclosed in the case makes you aware of something that might potentially create a conflict of interest. Prior relationships with law firms that you might have worked with that are now involved. And also, when it comes to that, the part about withdrawing, I suppose I would urge mediators to always err on the side of caution. So that if you've disclosed a conflict of interest and the parties want you to continue in the case, I would really recommend, getting that agreement from the parties in writing, so that it's not a case that 6 months down the road, one of the parties decides, you know what, I'm not actually that happy with what we agreed in mediation. I'm going to go after the mediator here because, they had a conflict of interest, and sure, they were never going to be. I know we said we'd keep them on, but so, I suppose, again, better to be prepared for eventualities like that. I don't want to come across as unduly negative, but it's an onerous enough obligation. So beware, mediators, if there are any conflicts of interest or perceived conflicts of interest.
Yeah, okay, so it sounds like the mediator's role now has higher than normal administrative load
Yeah, and actually, if we move on to the next set of obligations, because that is not the end of them, you'll see that there are a few additional ones as well. Okay, so the next obligation then is to furnish the parties with details of your mediation qualifications, any training you've undertaken, any CPD you've undertaken, and which code of practice you adhere to and you practice under. So that all has to be given to the parties. Then there is a duty there to act with impartiality and integrity and to treat the parties fairly. I would like to think that that would be ingrained in any mediator anyway. It doesn't specifically have to be set out in the Act, but it's no harm to set out what the expectations are from mediators. Then there is the obligation to ensure that the parties are aware that they have a right to obtain independent legal advice. And then the most interesting of these obligations, which could also be called a right, if you like, or a power, comes back to what I was talking about at the beginning around just how facilitative is facilitative, namely that the mediator can, on request by all the parties to the mediation, make a proposal for settlement. Okay, so the parties can say, hey, Mr. or Mrs. Mediator, we're kind of stuck here. We'd like you to make a proposal as to how we should settle this. The mediator can make that, and then it's up to the parties to decide whether to accept and run with that proposal or not.
Okay, so I'm assuming that if parties are stuck in a mediation, that's why they engage the services of a mediator to help them get unstuck. So how is this different from conciliation then, if the mediator can make a proposal?
Well, this is the key question about this, and I suppose if we're coming at facilitative mediation from a kind of a purist standpoint, we would say that if the parties are stuck, the mediator has a lot of tools at their disposal to help the parties themselves become unstuck without saying, here's what I would do if I were in your shoes. But this provision does stray into the territory of conciliation, where it allows the mediator to put on a expert hat, if you like, and say, actually, guys, this is what I do in your shoes. And that has a couple of implications. Now, it has implications, obviously, for lawyers, okay? So if I'm a lawyer and I'm looking at selecting a mediator for my client's dispute, given the fact that this opportunity is there to sort of bring the mediator, if the parties so desire, into a kind of a conciliation process, I will obviously be looking for mediators with a bit of subject matter expertise who will be able to make a proposal should the parties so wish. So that kind of really, that's quite significant in terms of how mediators then go about marketing their services, because it's no longer then just about the mediation skills. It might also be about the subject matter knowledge if the mediation is, for example, relating to intellectual property rights, let's say. Okay. On the other hand, then it has implications for mediators who, again, for marketing and how they sell their services, but also who could be superb mediators with excellent skills and great, deadlock breaking skills, but might not feel comfortable or be in a position where they wish to or feel that they can make a proposal for settlement. So as mediators, we need to think about what will we do in that situation if the parties say, hey, we're stuck, what would you do? And can you make a proposal for us? And we don't feel comfortable making that proposal. Again, I suppose the latent lawyer in me always looks at the worst case scenarios in relation to these provisions and says, if I am making a proposal and the parties agree to accept it, I'd be making sure that I copper fasten that mediated settlement agreement and say that the parties will not be holding the mediator in any way responsible if it turns out that the mediator's proposal ends up being unworkable, or the parties decide in retrospect, actually that wasn't a good idea at all, that you're protecting yourself there as a mediator, because all it will take, I suppose, is one of those mediators' proposals to end up not working out, parties blaming the mediator, and me having to make a phone call to my insurance company.
Yeah. So just on that note, the mediator can make a proposal only at the request of the parties. So the parties
and all the parties.
Okay, so the parties have to initiate it. So the mediator can't decide, okay, look, guys, you seem to be stuck. I've got some suggestions, No,
the parties do have, according to the legislation, the parties do have to request it.
Okay.
Yeah, whether the mediator plants that seed or not is one of the questions that we will have to see how it pans out in practice,
Indeed. Interesting. Okay.